Dat is prettig. Ik wil graag starten met de introductie van onze hoofdspreker van vandaag. Dat is Theresia Degener. Zij is professor-dokter in de rechten en in disability studies aan, en nu ga ik het even voorlezen, de Evangelische Fachhochschule Rijnland-Westfalen-Liepen in Bochum, Duitsland. Helemaal goed? Ja. En zij is voorvechter van gelijke rechten. Dat zult u ongetwijfeld straks merken. En ze is tevens vicevoorzitter van het VN-comité wat zich bezighoudt met de monitoring, het volgen van de implementatie van het VN-verdrag. En zij zal voor ons spreken over die implementatie van het VN-verdrag voor de rechten van de mens met een beperking. Alsjeblieft, the floor is yours.
Yes. Hello, everyone. I'm delighted to be invited to this conference, and I thank the organizers, the Coalition for Inclusion, for inviting me to this interesting event. I have heard great things about your work, about the project UN Treaty Around the Corner from Agnes van Wijnen, with whom I've worked for many years by now. The invitation also gives me the opportunity to come back to the Netherlands, the country where I had my first job after graduating from my final law exam back then in the 1990s. When we did the project on human rights and disability in 1994 with the Gehandicaptenraad, Jolanda Costa-Dreese and me, we edited a book called Human Rights and Disabled Persons. And in that book, we stated that there is a dire need for a human rights treaty for persons with disabilities. While the Gehandicaptenraad did back then very pioneering work in human rights and disability, we did not foresee how soon history would prove us right. Only a decade later, the treaty was in the pipeline, and a little later was adopted by the General Assembly in 2006. We also did not foresee then that among all the EU countries, the Netherlands would be one of the last to ratify this treaty in the 21st century. Well, I think history is sometimes unpredictable. And I'm very pleased to hear that the Netherlands is shortly before ratifying and will join the state parties of the committee. Let me now tell you a little bit about my experience as a vice chair of the CRPD committee, which is the international monitoring body of the treaty. Within the next 20 minutes, I would like to talk about 6 items with you. I would first talk about the CRPD. Why is it a unique treaty, and what is so important about the CRPD? CRPD stands for Convention on the Rights of Persons with Disabilities. Secondly, I would like to tell you how does a country become a party to the treaty? What is the legal steps that country needs to take? Thirdly, I would like to talk about our CRPD committee and how it works. How do we monitor whether human rights for persons with disabilities are implemented in each country? Fourth, I would tell you a little more precisely about the reporting cycle and what kind of subjects do we raise when we discuss with the state parties. We call it the dialogue, when we have the dialogue with the state parties. The fifth point is the role of civil society in this cycle, and the sixth point is an example which I would like to share with you. Let me start with the first item. Why is it that the CRPD is a unique treaty? On the screen, you can see, if you can't see it, I describe it. You will see 9 circles, and each circle stands for a human rights treaty. within the United Nations, we have 9 core human rights treaties. And I haven't put down all the names of these treaties. They are far too long. I have just put down the abbreviation. And for instance, ICCPR stands for International Covenant on Civil and Political Rights. That one was adopted in 1966. And then there are many more treaties, like, for instance, CEDAW is very famous. That's the Women's Convention on the Elimination of all forms of discrimination against women. We have CAT, the Convention Against Torture, and we have the CRPD. The CRPD, as you can see, was adopted in 2006, which was some 40 years later from the first human rights treaty being adopted. The uniqueness of the treaty derives not only from the fact that it is the only treaty which focuses on disabled people, and it is the first time that we have a binding human rights law on people with disabilities. When the ICCPR and the other treaties were made, people with disabilities were kind of invisible people. No one thought of disabled people, even though everyone agrees that all the other treaties also apply to disabled people. But when we did a background study, a colleague of mine from Ireland, Jared Quinn, and me, we did a background study for the United Nations in 2000 on how are all these treaties applied to persons with disabilities. We found that most of the time they are forgotten. And that was the reason why we recommended also in 2000 in our background study for the Office of High Commissioner on Human Rights to adopt a thematic treaty. The CRPD is also unique in that it is the most modern human rights treaty. As compared with all these other treaties, it has, for instance, a national monitoring system. So all the other human rights treaties, they only have an international monitoring system. That is a committee, like a committee I sit in. We meet in Geneva, and we, from Geneva, we monitor whether the countries implement the treaties. The CRPD says, no. Each country which ratifies this treaty also has to have a national monitoring body. And that is a focal point within government and also an independent human rights institution which needs to do the monitoring work within the country. And civil society needs to be involved. The CRPD is unique in many other ways. For instance, it's the only human rights treaty which allows the EU to become a member. And the EU, the European Union, has already ratified the convention. So all EU members are already bound via the EU to the CRPD. And then the CRPD is also unique because it is the international manifestation of what we call the human rights model of disability. And that human rights model of disability is the successor of the social model of disability, which itself is the successor of the medical model of disability. I think most of you might have heard about the medical model of disability, which was the most dominant understanding of disability until the 1970s at the international level, but also in most countries. The medical model of disability sees disability mainly as a medical issue, and the problems disabled people have are seen as individual problems. Because you are impaired, you cannot, let's say, walk steps. Because you can't walk steps, you cannot go to regular school. Because you are blind, you cannot read, and you cannot take in the information which is publicly available. So the problem is located in the individual. And what you need is rehabilitation and cure. And during the 1980s, in most countries around the world, disability movements were founded or evolved, and these more radical disability movement criticized the medical model of disability as wrong. They said, it's not our impairment which is the problem, it is society. Society puts up the barriers. Society decides that we cannot go to regular school. Society decides that we are discriminated in employment. And so the social model of disability was basically the critique to the medical model. And it helped that most countries adopted anti-discrimination legislation and so forth. And the human rights model of disability builds on this social model of disability, but it goes beyond. It goes beyond the social model of disability because it sees disabled persons as right holders, not merely as welfare recipients. It also has what we call the capacity approach to disability. Most laws, most traditional laws, especially when it comes to mental health laws or guardianship laws, have what we call the incapacity approach. This incapacity approach says that because of an impairment, let's say a psychosocial disability or an intellectual impairment, that person is legally incapable of making decisions. And the CRPD says this is wrong. Every human being, no matter how severe or what kind of impairment he or she has a right to be legally recognized as a person before the law. And that means the concept of legal incapacity is wrong. We need to change the laws and see disabled people, all disabled people, as legally capable. The CRP or the human rights model also means that exclusion is a human rights violation. It's not just a problem, it is a human rights violation. Human rights model also means rehabilitation cannot remedy human rights violations. It is important, but it cannot remedy human rights violations. It is society which needs to change. All these ideas can be found, of course, in the text of the CRPD, and we do not have the time to go through the whole text, but I just want to mention a few articles which I think in this context are very important. Article 1 spells out the purpose of the treaty, and it says the purpose of this treaty is to help that all people with disabilities shall enjoy the full range of human rights. And then Article 3 contains the 8 guiding principles of the treaty. And they are non-discrimination, accessibility, dignity, and the acceptance of impairment or disability as part of human variation, as part of humanity. Disability is not seen as a deficit. It is seen as part of a human variation. And Article 33, I mentioned already, demands that each country has to have a national monitoring mechanism. And then what is also very important, and it often is forgotten, Article 32 is a standalone article on international cooperation and development. And that is very unique too. If you look at the other human rights treaties, you won't find a standalone article on the right to development. The CRPD has it, and it is the background for this is that the disability was forgotten when the Millennium Development Goals were adopted by the United Nations in the 90s. And poverty and disability are intrinsically linked. Of the 1 billion disabled people around the world, 80% live in developing countries. So poverty and disability usually go together, and if we want to change that, we need to think about disability-sensitive and inclusive development policy. Okay, I come to the second point, which is how do you become a party to the CRPD and the OP, which stands for the optional protocol. Most human rights treaties come with a second treaty, which we call the optional protocol. And most of the time in this optional protocol, there is special procedure in. And so it is with this. In the optional protocol to the CRPD, there is the procedure for individual complaints and other procedures. So, normally we have a two-step procedure. Countries do sign a treaty, and after the signature, they ratify, usually through a parliamentary decision, or the president may also take that decision. It depends on the constitution of the given country. There is also a one-step procedure, which is accession or a formal confirmation. It depends on the constitution of the country or of that particular organization. What is important is that once a country has signed, as the Netherlands has, it makes a promise. The promise that it will take steps to be bound by the treaty. And even though the Netherlands has not ratified yet, it is under the obligation to refrain from counteraction. So whenever the Dutch government, before ratification, does something which goes counter the CRPD, it already violates its duties under the treaty. Once it has ratified, it is legally bound by the CRPD. And then there are different ways how to make an international treaty part of your domestic jurisdictions. Each country is different there, but usually what happens is that the government has to adopt a number of laws in order to import the contents of the treaty into the domestic legislation. But some of the treaties are also, and I'm pretty sure that we can discuss that with respect to the CRPD, they are also immediately applicable. Okay, I come to the third point. How does the committee work? How do we function? The CRPD committee consists of 18 treaty members, and all of these treaty members are independent members. They cannot be part of the government. The CRPD has, at the moment, 134 parties which have ratified, and 158 signatories. The optional protocol has 77 parties and 92 signatories. Until now, we have received 46 state reports, and 59 state reports are overdue, which means they had to be submitted to us in the past, but they didn't, and we are still waiting for them. We have by now, and we just had the 10th session in Geneva in September. We have 10 states fully reviewed. We have now 5 weeks meeting time in Geneva. We meet in April 2 weeks and in September 3 weeks. And you can already see that having only reviewed 10 states, it means we are already having a backlog. At the moment, we have a backlog of 5 years. So if the Netherlands will submit its state report to us today, or would submit it within 5 years, we would be able to review it. We will work on it because the General Assembly has already announced that they will give us more time to work on the reports. Okay, what are the other agents? When we do our monitoring, who is also working, so to say, on the side of us? First, you must think of that there are also 9 other treaty bodies. Remember the circles on my first slide? I said there are 9 treaties, but one treaty, the anti-torture treaty, has 2 committees. So altogether we are 10 treaty bodies. And of course, when our committee makes a statement, we also look to the other treaty bodies and see how did they deal with the issue. Because the idea is that we harmonize our jurisprudence, that we not one treaty body goes into that direction and the other in this, but so we also discuss our legal problems with the other treaty bodies. Then we also must take into account that there is a state party conference in New York City every year. This year it was in July, and the state party conference is a meeting of those countries which have ratified the treaty, and they exchange good practice examples, but also problems. The State Party Conference cannot file a judgment or a recommendation on a specific country. That's what my committee can only do. And then, of course, there is the national monitoring system. So we work together a lot with National Human Rights Institute, which are the national independent body of a given state party. Here you can see, for those who can see, a picture from our treaty body. It's a little bit outdated because our current chair is a female, but I didn't have a good picture of this, the last session. So here you see our chair from 2 sessions before, Ron McCallum, a lawyer from Australia. And it's in the room where we meet in Geneva, and at that time we had China as under review. So our biggest task is to review state party reports. State parties have to submit a report to our committee, first 2 years after ratification and then every 4 years. And in those state party reports, they need to explain to us how did they implement the treaty, where do they see problems, and what is their plan for the future. We also hear individual complaints from those countries which have ratified the Optional Protocol. By now we have 6 cases decided, and I just want to mention two which we just decided against Hungary because they are very interesting. The one is Nusti versus Hungary, and that it was a case about blind people from Hungary who filed a complaint against their bank because their automatic teller machines were not accessible to them because they did not have Braille. And they went to court in their country, and they won the first round, and then the bank said, okay, we give you Braille on your automatic teller machines in your neighborhood. But then the blind people said, no. We want to travel around, and we want that in all over the country, all over Europe, where you have your automatic teller machines, they must be accessible to us. So the bank was very angry, and they said no, and the Constitutional Court gave them right, and so they came to us. And we just decided that the blind people have a right to accessible automatic teller machines throughout the country and throughout Europe, because the bank is operating all over Europe. In Bodozo versus Hungary, people with psychosocial disabilities filed a complaint against their government because they were not allowed to vote, because they were put under legal guardianship. And they were unsuccessful in the country courts, and they came to us, and we just gave them the right and said, yes, Hungary needs to change its guardianship laws because it is a violation of Article 12 if someone under guardianship cannot vote, or if there's assumption that an impairment makes some incapable to voting. So Bodozo versus Hungary and Nusti versus Hungary are just recent cases which I think are groundbreaking. So we also have inquiry procedures and early warning measures. I think my time does not allow to go into details here. Let me just mention that we also adopt general comments. General comments are interpretations of certain articles, and they are not legally binding in the sense of a judgment, but they have kind of an authoritative statement. And we just adopted just this September a draft on accessibility, Article 9, and on Article 12, legal recognition as a person before the law. And we are very eager to hear the input from the public. So we would ask you to go on our website, look at the draft general comments, and give your comments to us if you think we interpret the articles in the right way. We also issue a statement. We just adopted a statement on Syria and how disabled people are forgotten in the war, and what the government of Syria is obliged to do. I come to my fourth point, the reporting cycle and issues of dialogue. When a country submits a state report to us, what happens is we read it, and then we formulate the list of issues. The list of issues are questions we have to the country. Let's say the country says, oh, our inclusion rate is very good. 80% of all children with disabilities go to normal school. Then we would put a list of issues as an issue. We would ask, okay, how many of these kids in regular schools receive reasonable accommodation? Or how many of these kids receive special education in regular school? And what happens to the 20% which are not in regular school? So after we have adopted the list of issues, the governments have to respond to this list of issues. And then the next step is the constructive dialogue. That means that the government or the representatives of the government come to us, to Geneva, and then we have a full day or 2 half days of dialogue with the country. And then we confront them with information we gain from other sources, not the government, but from NGOs or from other human rights organizations or other UN organizations. And then we have what we call a constructive dialogue. And then we do our concluding observations, which is a kind of a judgment. It's not a judgment in the sense that it is a court decision, because we are not a court, we are just a committee. But our concluding observations has some kind of authoritative character in that it is embarrassing for a country if we say you have violated your duties under this treaty. What are the issues in our dialogue? Well, of course, the human rights model of disability is an issue. We talk a lot about ending institutionalization. Many countries still have large institutions for disabled people. And even those who are more modern countries still have a very institutionalized approach to disability service. And even small group homes can be small institutions. So we talk a lot about institutionalization. We talk a lot about abolishing segregation. Guardianship is a huge problem in most countries, and many countries, because of our recommendations, have already changed their mental health laws. Ireland is an example. Ireland has one of the most modern legal capacity laws now. The freedom and equality for disabled women and the rights of disabled children are usually issues we talk a lot about with the countries. Well, how can civil society play a role in this circle of, in the reporting cycle? The most important thing are alternative reports. When a state submits its report, for instance, China has submitted a report to us, or now we were discussing Australia and Austria and El Salvador. All these, in these countries, the NGOs, the DPOs, organizations of people with disabilities get together and formed coalitions, and they presented us with so-called alternative reports. And in these alternative reports, we found statistics and description of how the situation is from the point of view of the NGOs. And of course, you can imagine it read very different from what we read in the state report. Often the state reports are like, descriptions of Wonderland. The government always says we are doing everything fine and we're doing wonderful things and we spend so much money on the disabled. But when we read the alternative reports, then we find, they spend money on building institutions. They spend money on preventing road accidents, but that does not have anything to do with human rights of disabled people. So alternative reports prepared by NGOs, prepared by local DPOs are very important. Then when we adopt the list of issues, we often get recommendations from the NGOs, and that is very helpful for us. They help us to ask the right questions, And then when we have our constructive dialogue, we again get questions from the NGOs, from the DPOs, and what kind of questions do you want us to ask? For instance, let me briefly give you the case of China. China is a country which has serious human rights problems. You can all imagine, we all know it has a very bad record. But we got a lot of information on how badly they treat disabled people, especially young boys with intellectual disabilities. What they do is the big mining companies kidnap them in the streets in the rural areas, make them forced laborers in the mining company, and then after some time they explode the mining company. They pretend an accident. All the boys are killed, and then the mining company asked for damages from the insurance company because they lost workers. So we got confidential information on 400 cases of young boys kidnapped in the rural areas, made forced laborers, murdered in the mining companies. And we confronted the Chinese government with that information, and China did a lot of things in preventing us from making that material public. But we did it, and we managed to confront China with it. And in the end, they admitted that it happened, and they promised that they would do something about it. It doesn't mean that these boys come to life again, but it was very touching for me to have the parents of some of the kids in the NGOs sitting in the back of our room and listening to us. And they came to us afterwards and they said, thank you that you made it public, and thank you that finally we can publicly say our kids were murdered by the mining companies and the government is responsible for it. So it is important to have civil society involved as information giver, as people who consult us on asking the right questions, and so forth. Well, I come to my last point. The last point you see, for those who can't see, I have a picture from Tokyo showing a situation in front of a Japanese court in Tokyo. And this happened in March this year. And the case concerned a Down syndrome woman who was not allowed to vote because of her intellectual disability. And she went to court in Japan, in Tokyo, and demanded that she is allowed to vote and that government has to change its legislation. And the District Court of Japan, even though Japan had not ratified yet, Japan has not ratified the convention, they only signed it. But the judge in District Court of Tokyo said on 13th March this year that Japan has violated its duties under the CRPD, and the fact that this woman has a Down syndrome is not a legitimate ground to disenfranchise her. So she won the case, and I just want to give you an example that sometimes the treaty can make a difference already before the country has ratified it. So ratification, once it is done, is only the beginning. Implementation of human rights is a long process. It will not happen overnight. Meaningful participation of civil society is crucial, and international monitoring needs to be complemented by effective national monitoring. That is what I wanted to tell to you, and I thank you so much for your attention.
Thank you very much for all the information you gave us, and especially that we now have an idea how the treaty can support us towards inclusion. And you gave some beautiful and hopeful examples, so we're looking forward to that. Thank you very much. I'd like to offer this to you. It's a coin in remembrance of the 100th birthday of the Peace Palace. Okay. It's nearby. And of course, peace is all about human rights. So we thought it was an appropriate gift to you. Thank you very much.